I'd like to talk a little bit about the use of machine translation in creating prior art. Now, when I began as a patent attorney a little over 20 years ago, normally the only prior art that would be cited against us by examiners was either from the United States or EU or sometimes from Japan. A lot of the patents, particularly those filed in other countries, would never make it into the US as applications or patents, and they wouldn't be translated, so it was very difficult for the examiners to find anything. Well, fast forward to today, and the situation is much different. There are machine translations available through Google Patents, Spotnet, Chinese Patent Office, a bunch of other organizations where the machine translations of foreign patents, including those that were never filed in the United States, can be had, where these foreign patents are translated into English. And so what I'm seeing more and more right now are these foreign patents that there's no way that anybody would find out that they were ever filed, because they're filed in a foreign language in a foreign country. And until these patent translation services came into being, there's no real way to figure out if that particular patent may be relevant to your patent application. So now, and with AI being what it is, I expect that to be even more common in the future. So whereas in the past, almost all the rejections that we get of the prior art cited would be from the US, EU, and sometimes Japan, now I'm regularly seeing machine translations of patents from the Japanese Patent Office that were never filed in the US, Chinese Patent Office, South Korea, Taiwan. And again, with AI growing at the rate that it's going, I think that it's safe to say that 5 years from now, you're going to see patents that were filed in foreign countries that normally weren't considered to be exactly on the cutting edge of technology, where people or the examiners are going to have access to those too. So where does that leave you as an inventor? Well, again, 20 years ago, there were kind of two approaches to getting a prior art search. A prior art search, again, is where you hire a company that goes out and looks and sees what kind of other patents and published patent applications there are prior to you deciding whether or not to file a patent, so you can kind of see what's out there and see whether you think you've got a reasonable shot at getting some kind of reasonably strong patent. And again, 20 years ago, there were two approaches to this. One approach was, well, let's do the prior art search. So first of all, we see if we think we've got a reasonable shot of getting around the prior art. And second of all, as a patent attorney, it's easier for me to draft a successful application if I know what else is out there. I mean, it's kind of self-defeating if you file a patent application without a prior art search, and the first office action response, that's where the USPTO examiner examines your application and comes back and gives you a rejection. Well, again, it's almost embarrassing when you get one back that basically says, hey, if you'd spent 10 minutes on a prior art search, you would have found these 3 patents. I'm rejecting your application over. But so that didn't always happen, because the examiners didn't always find everything. So the contrary position was, why should I do the examiner's work for them? Why should I pay for a prior art search? Let's just file the application, let the examiner do his or her job, search for the prior art, and then if they don't find anything, then I get a patent, and it's great. And so this resulted in, at least in my opinion, in probably a greater percentage of patents being granted. But the patents that were granted were probably weaker than the patents that would have been granted had a prior art search been done. Because when you do a prior art search, you're adding your research to the examiner's research. So the examiner has more things to go over when deciding whether to give you a patent or not. And as a result, if you do get a patent, the patent's probably going to be stronger. So anyway, again, that was the situation 20 years ago. Now, with machine translation, I would say it's really, really important to get a prior art search done prior to making the decision to file a patent application. And you've got to have a more thorough search than was done before. I mean, 20 years ago, if you did a search, it was US, EU, Japan. That was pretty much it. And with Japan, you're looking for the patent applications that have been filed, or at least translated partially into English, or the ones that had used Japan as a priority office and have been filed in the US. Well, now with machine translation, I think you can count on um, patents being found in quite a few countries where the technology is advanced enough so that their inventions could be relevant to your invention. So I would have a prior art search done now. We cover the United States, EU, Japan, South Korea, China, Taiwan, Australia, and depending on how things go in the future, probably India as well. And again, that's right now. 5 years from now, I may change my mind. I may be recommending a lot more countries. So anyway, I think the bottom line is that with machine translations getting better and better, and at least the United States Patent and Trademark Office using them more and more, I think it's more and more important to get a really thorough prior art search done before you make the decision to file a utility or a provisional application. Now, this is for utility and provisional applications. With design patents, obviously, the shape of the item is what's important as opposed to its function. And so you can also have a prior art search done on design patents. I don't think that the software is technologically advanced to the point where it's going to go through all the other patent databases in all the other foreign countries and look for similar shapes, but I'm sure in the next 5 years that's going to be there. So a couple years from now, I will probably be doing another video on that topic. All right, that's all I have. Thanks for watching.